and thank you for joining us. And we're excited to have you back for yet another session. Please do feel free to introduce yourself and where you're joining us from in the chat. And just a quick recap. Today is the second session, or the second webinar rather, in our series, building on the last session we had, which focused on corporate governance. During that session, we discussed how strong governance frameworks are essential for building trust, driving sustainable business practices, and ensuring a long-term success. So if you missed that particular session, you can always revisit our recording to catch up on our YouTube channel. So today we are shifting the focus to two critical areas that intersect with governance. And these two areas are intellectual property and data governance. So these are absolutely essential for protecting your business's core assets and ensuring compliance with evolving legal standards. So before we can actually dive in, let me just give a brief overview of the organizations behind today's session. Bongo Hive, we are the ones that are hosting this particular webinar, is an organization that is committed to supporting businesses across Zambia and Africa by providing innovation-driven solutions to empower startups as well as entrepreneurs. And we are very proud to partner with MOIRA Legal Practitioners, who bring a wealth of expertise in business law, data protection, and intellectual property. Now, I will now pass it over to our speakers to introduce themselves and give you a quick background on their expertise. So I will now hand over to Nabanji Nebwe, who will now give an overview of herself. Over to you, Nabanji.
Thank you so much for that introduction. Good evening, everyone. My name is Nabanji Newe, and I am an associate here at MOIRA Legal Practitioners. MOIRA Legal is a corporate law firm. We are located in Lusaka, Zambia, and we specialize in capital markets, banking and finance, you name it, mergers and acquisitions, corporate and commercial transactions. And our guiding principle as a firm is seeing beyond and unlocking possibilities. Apologies for that. I'm just being guided to turn on my camera. Hopefully you can all see me. There we are. Right. So MOIRA Legal is a corporate law firm, and our guiding principle is seeing beyond and unlocking possibilities. And this is a principle that we carry in all our work and in our service to our clients. In terms of my experience and expertise, I currently serve as associate in the banking and finance division of the firm, but I also lead all things to do with intellectual property and innovation as well. And it's a pleasure to be with you this evening. I'll now hand over to Chimwemwe to introduce herself. Thank you.
Good evening, everyone. My name is Chimwemwe Walia, and I'm a senior associate at MOIRA Legal Practitioners. I'm very happy to be here with you all, and I hope that you can learn a thing or two about data protection and intellectual property. So here at MOIRA, in terms of my practice areas, I am in the corporate department. So I specialize in data protection, tax law, I do tax litigation, I do commercial law, corporate law, anti-money laundering. I do a lot of regulatory and compliance work, advisory work. I do it all. So that's just my expertise. But today I'm coming here as someone who is very, very passionate about data protection compliance, data protection risk management. So please, I hope that during this session, you can learn a thing or two. And if you have any questions, please feel free to put the same in the chat box and we'll be happy to address the same. So thank you. Over to you, Kasiku. And while we are presenting, I think just for you to see the material, we will turn off our cameras.
Okay, great. Thank you for those amazing introductions. And before we dive into our discussions, just a quick reminder on a few housekeeping points. Firstly, feel free to submit your questions in the chat throughout the session. We will be holding a Q&A session at the end of both presentations, so don't hesitate to ask anything that comes to your mind. We'll take a couple of questions after the session. And the third thing is we aim to wrap up the session in at least 1 hour, 30 minutes. So we'll ensure that there's enough time for everything. So now let's get into our first topic, which is intellectual property. This is a vital area for business, for any business that is looking to protect its innovations, its trademarks, and technologies. I'm sure you will find today's session very insightful and very interesting. So now I will hand over to Nabanji, who will dive into the key aspects of intellectual property. Over to you, Nabanji.
Thank you, Kasiku. Right, so today we're going to be looking at copyright as well as trademarks, because intellectual property is a very vast area of the law, but we thought that these particular IP assets would be of benefit to you this evening. And so the overview of this session is, as outlined, we'll look at copyright protection for business content, the key elements of copyrightable work, license agreements, workplace IP ownership risks, and lastly, we'll have an overview of the new Trademarks Act and address trademark registration and enforcement. So how can businesses protect their business content and software assets? Well, the first is recognizing that business content and software assets is or are rather copyright protected. So the Copyright and Performance Rights Act 1994, although dated, currently protects all copyrighted or copyrightable work in Zambia. So this includes original literary works, computer programs, as well as cable programs and other forms of copyrightable work. So what does it aim to protect exactly? Well, copyright is a right that subsists in original authors or creators of a work. It does not protect replicas or duplications. And the whole idea is that as a creator of a particular work, I should be entitled to benefit from the work, whether it be through my own use or use by other people. So copyright is a right that subsists automatically upon creation of the work. In the light of this, registration of such a work is voluntary. So you need not go to PACRA per se for it to apply, but registration does create solid evidence of an existing right. So in terms of the key elements that subsist in a copyrighted work, the first is originality. As I earlier alluded to, a copyright only applies to original work. It does not apply to replicas, to duplicates, or anything that is copied from somebody else's created work. A copyright holder is entitled to protection of their work for their lifetime, plus 50 years after their death. In the event that copyright is held by, say, 2 or 3 or more individuals, the right will subsist for the lifetime of the last surviving owner plus 50 years of their life. So that's just an important thing to note. The next and one of the most critical values, or rather concepts of copyright, is idea versus expression. So copyright does not subsist in ideas. You can only claim copyright for created works or the expression of the work. So an idea for perhaps a software that sorts data in a particular fashion versus an actual code that does the same thing. Copyright will only subsist in the created code and not in the idea, irrespective of whether the person that had the idea had it 10 or 15 years ago. They cannot claim that they were the brainchild behind this particular work simply because they had the idea to create that particular software. The person that expresses it in code has created the work, and for that reason, copyright will apply to that created work. So in terms of software protection and licensing agreements, copyright bestows on the right holder the right to license the agreement. What this means is, considering that a copyright holder is the owner of the created work, they are allowed to exploit that work or benefit from the work that they have created. This therefore means that they can use that work or permit others to use the work. And this is achieved mostly through licensing agreements. Now, here we have an example of an everyday licensing agreement. And this is actually taken from maybe someone's phone. This is Apple software licensing agreement. And normally we just skip past this, scroll, and click accept without knowing that we're actually licensees of Apple software or Samsung software or whatever the case may be. And so this particular agreement is a one-use or a single-use license agreement, and it outlines your rights as far as use of the software is concerned. So whilst you use your device, you are not permitted to duplicate the software. You're not permitted to develop on the software or create any other works from this particular software. However, the license also makes provision for subsequent licensing in the event that the person that has this phone is a software developer or is involved in the tech industry and would like to build on Apple software. They can actually apply for a license to develop this software and sort of expand it or mold it to do more than what it does at present. However, as far as your license applies, you're not entitled to do that. And so it's important to note that any created work is only protected to the extent that the creator enforces their rights. Here, Apple is, a huge company, but they're not taking it for granted that their software is being used all over the world, irrespective of whether you are an individual, a company, a tech startup. You are subject to licensing agreements and licensing agreements that apply to your specific band of use. So as an individual, you get this single use license. And as a tech startup, you would be subject to a different license for which you would have to pay a particular subscription or royalty fee. So licensing, as we can see, it's a fundamental tool, and it's used in the protection of numerous copyrighted works, including software. So in terms of enforcement of copyright for software, it's actually not easy at all. It's easier said than done. And the reason why is because infringement of copyrighted software is difficult to detect very often. There aren't many flagging, institutions or mechanisms that exist to alert software developers that, one, maybe their software is being used without a license, or two, being distributed without a license. Software distribution is also copyright infringement if it is done without the consent of the copyright holder. And in light of this, for creators of software, of course, that's welcome news, but for end users, it's a call to ensure that your licensed software is in fact licensed by the copyright holder. Otherwise, it exposes us to risks of losing data or information that may be essential for our business operations. So how can we combat these challenges? What are the possible solutions? The first is ensuring that we have adequate documentation of software or copyright development processes, as well as timelines. The second is registration of the intellectual property. So although copyright is an automatic right and registration is voluntary, registering the right ensures that you have adequate evidence of actually having created that work and registering it as well. And the last is sufficient analysis of any claimed duplication or infringement of your right. The last thing you want to do is commence a suit, not having fully analyzed whether or not this work is original or not, or derived from your work, or possibly even derived from open access to software codes or data. We're living in a world where AI is increasingly dominating all creative spheres, including copyrighted work. And on this basis, any information that is derived from open access or open sources of information cannot be claimed to be solely original, because the basis for that particular coding or information that you would have received is available to the public. So next, we are going to delve into IP ownership risks in the workplace. So who owns the IP that is created during the course of employment? According to the Copyright Act in Section 10, the owner of IP created during your work hours is in fact your employer. And this is the general position. However, it's possible for the employer to have an assignment agreement that assigns your intellectual property rights to another individual. This is particular in instances of commissioned works where the actual beneficiary of the work is a third party. And so that what this would mean is that for any future intellectual property that you create as an employee, the actual holder of that intellectual property would be the person that commissioned the work to be done. So this is a controversial topic because technically the person that created the IP is the employee. However, it's important to note that the employer is said to create the environment for the work to actually be performed or to be carried out, and for innovation to take place, as well as the formulation of new ideas. So technically, the entire reason why the IP exists is because the employer created the environment for you to create that solution or to do that work or create that innovation. Another important note is that IP in the workplace is governed by different rules depending on the jurisdiction in which it is made, as well as the IP rights in question. So a patent right normally subsists in the creator, irrespective of whether it's created during the course of a particular employment, whereas copyright would automatically apply to the employer, or rather subsist in the employer. For this reason, it's extremely important for both employees and employers to clearly understand what IP ownership rights exist and apply to their employment relationship. In the case of Makate versus Vodacom, This is a South African case, and it involved a simple conversation between an employee and his manager. And the genesis of this innovation or invention was very simple. He had challenges with speaking with someone who was living far away, and they never seemed to have enough airtime to actually call them. And so he thought, why don't I make a solution to this? What can I do? And so he decided to invent what's called Please Call Me Now. And it's pretty much a service that allows you to almost page someone without having the required airtime credit, and they can call you back. So you send them a please call me. And what happened was he shared his idea, not having documented anything, but had a simple conversation with one of his managers. And he was working in finance, nothing related to marketing or innovation or anything of the sort. And he had a conversation with his manager, and he said, I have this brilliant idea. I don't know what you think. And the manager said, oh, we'll give it a go. And in the event that it has any commercial success, I promise that you'll get something from the proceeds of this invention. As fate would have it was a huge success at the time. I think this was early 2000s. And nothing happened for him. He left the company after 8 years and then decided to sue. And the matter ended, I think, just last year. The parties decided to settle the dispute out of court. What's interesting is that this particular solution was already patented by MTN at the time. And so, although there were small nuances between the MTN solution and this new Vodacom solution, they decided not to request a license from MTN, I guess on the basis that the solution was different. And at the same time, MTN didn't oppose their new software because the idea was that they didn't want the backlash from two big companies in the same industry being seen to be fighting over this particular innovation. And so this is just one example of how IP rights in employment can actually be not only beneficial for the company, but also can be the subject of dispute if not properly outlined, if not properly agreed upon, and if not properly documented. So having addressed copyright, I will now quickly delve into the Trademarks Act of 2023. We've been seeing a lot of conversation around it and all the new provisions that it has introduced. But the reason behind this reformation rather, is that the previous act was extremely old to begin with. It was a very old act made in the early 90s, obviously to comply with international standards for trademark protection at the time. But since then, there have been significant developments as far as trademarks are concerned. And so we needed a modern act to protect trademarks adequately. So one of the new provisions is Section 55 of the Act, which identifies trademarks as personal property. And so this provision says that they're capable of being transferred or being pledged or forming part of your will as a testamentary disposition. And more than that, they are also capable of forming the subject of a charge or of a security. And what we're seeing here is that trademarks are actually valuable in that sense. This therefore means that you can actually obtain a loan or funding and have your trademark as collateral for that particular financing. This is also supported by the fact that you will have to register such a charge or security at the collateral registry with PACRA. Another interesting provision in the new act is that it provides for registration of service marks. So previously, international treaties recognized the importance of service marks, which are marks that identify or distinguish the operations of businesses in the service industry. So, for example, a law firm has a different class from a trading company that deals with commodities. And now what we have is legislation that provides for registration of these service marks for service industry companies. Before this introduction, companies in this industry would just register under what's known as Class 16. And this is pretty much just a standard class that applies simply to publications or paper or stationery, that sort of thing. So the idea is that for whatever it is that you produce, it's protected by the trademark. But what we have now is specific service marks that apply to law firms and to other sectors of the industry that provide services, tourism, and so on and so forth. So trademark registration, why does it matter? Well, first and foremost, your trademark is your image. Your trademark is your brand. Any business, any company, any institution is known by what they put out and what people actually see. Individuals, we get the opportunity to speak for ourselves, pitch and say who we are and what we stand for. For businesses, this is the same thing. Your mark is your identity. And so for trademark registration, this can be done at PACRA. The registration process is fairly simple. You fill in the relevant form, you submit a specimen of your mark, you pay a prescribed fee, and provided that there are no hiccups, your mark proceeds to be published in the Industrial Property Journal and remains there for at least 60 days to allow any parties that may have a similar or identical mark to object to that particular mark. Now, this brings in the important question of trademark searches and why companies have a tendency not to conduct them. So a lot of the time we hear people say, register your mark, ensure that your mark is registered. But the question is my mark actually capable of registration? Does my mark infringe anyone else's registered mark? Or is it actually distinguishable from somebody else's mark? The last thing you want to have is a mark that can easily be confused for somebody else's mark. And so a trademark search is imperative. Before any trademark registrations take place, we encourage businesses and individuals to conduct a trademark search that will ensure that they identify any existing trademarks that may be similar to their current or proposed mark, and also to ensure that they have a solid basis on which to apply for the trademark registration. So you want to go into it with confidence, knowing that I'm registering this mark, knowing that there's no likelihood that somebody else will come and object to the registration or to the application of my registration for this mark. So what are the rights of a trademark owner and why are these important? Well, as I earlier stated, a trademark ensures that it distinguishes entities and one business from the other. But more than that, you have the right to actually object or oppose the registration of other marks. So where an application is made for registration of a mark that is identical or similar to yours, either in the same class or applicable to the same goods, then you have a ground on which to object to the registration of that mark. Additionally, where a mark constitutes a similar element, a reproduction, an imitation, or even a translation of your mark that is already established and well known, you have a basis on which to object to the registration of that mark, provided it is in the same class or applies to the same goods to which your mark or service mark applies. The whole idea is that it is going to cause confusion in the market, and you want to avoid that at all costs. And the final scenario is where the mark constitutes an essential part of your registered mark or a reproduction of your mark and it is in a different class or applies to different goods. However, people seeing that mark would form a connection between the two marks. So irrespective of the fact that it is applicable to different goods or to a different class, the fact that the mark is similar enough for people to form a connection means that it is likely to cause confusion or to deceive them, and could also result in damage to your interest as a proprietor of your mark. And the last one, which is very interesting, is where a proposed mark is likely to cause confusion with the name of a company or a business registered in Zambia. Now, this is interesting because typically, or prior to this act, trademark law only applied strictly to trademarks and not to business or company names. However, now what we're seeing is that where a proposed trademark has the same or similar name or an essential part of a company's name, that would also be grounds for opposition to that registration, because it would cause confusion or create a connection between the mark and the company, which in essence would damage the reputation of the company. So objection to a trademark application is made within 60 days from the date of publication of the mark in the Industrial Property Journal that I mentioned earlier. And once that's done, the applying party also has 60 days to file a counter statement stating the reasons or the grounds on which they propose that their mark continue or proceed to registration. Thereafter, you as the applicant will have 30 days to respond to that party's counter statement. So in the event that the registrar finds that your opposition lacks merit, maybe there isn't likely to be any confusion or deception to the members of the public, it will be dismissed without a hearing. However, if there is grounds to believe that there is likely to be confusion, then the registrar may proceed to hear the application, and after hearing both parties may either refuse to register the mark or to register the mark with or without conditions. Now, having spoken about the importance of both copyright as well as trademarks, intellectual property is at the heart of every business, whether it be internal with created works within the business or external with trademarks and other intellectual property assets. Key takeaways include recognizing existing internal intellectual property. This is essential to ensure that it is well documented, that the appropriate proprietors are afforded their rights, are well identified, and also to sensitize members of the public as to the protected works. So this may include using this copyright symbol here with the C or the trademark symbol next to any registered trademark. The idea is no one is going to go to the trademarks registry or the copyrights registry to determine whether or not your intellectual property assets are registered. It's up to you as the owner or the holder of this intellectual property to ensure that your rights are enforced and that members of the public as well as competitors are put on notice as to your registered intellectual property. And that brings me to my next point, the importance of registering, licensing, and enforcing your intellectual property rights. So registering ensures that you have that right. Without it, especially for trademarks, you cannot enforce any sort of enforcement against somebody else. Having that trademark certificate is imperative to ensure that you as a trademark owner have a basis on which to oppose or object to any marks that may be similar or cause confusion within the market. Similarly, licensing can ensure that you not only generate revenue, but you also expand the reach of your mark or intellectual property assets. And lastly, enforcing your rights ensures that you have adequate protection of your brand image and your commercial investment. I mean, as we can see from Apple, such a huge company, they're not neglecting the individual person that just has the iPhone. They are ensuring that that person is also subject to licensing agreements. And the same applies to techs, to startups, to developers, whoever it may be. And with that, I'd like to conclude my presentation and thank you all so much for your kind attention. Over to you, Kasiku.
Thank you so much, Nabanji, for that fantastic session on IP. You've covered some crucial points from protecting trademarks to copyrights to leveraging IP for your business. And as we move forward, let's just take a moment to just do a recap of the key takeaways. At least this is what I got from the discussion. The importance of securing your intellectual property assets early on to maintain a competitive edge within your business, and also how IP protection plays a crucial role in safeguarding your business ideas and your brand identity as well. So thank you so much for that. And now let's move on to our second session, where we're going to dive into data governance, a topic that's becoming increasingly essential in today's data-driven business environment. And before we do, please feel free to drop in all your questions in the chat, and they will be addressed at the end of today's session. So I will now invite Chimwemwe Bwalya to introduce data governance and explain its importance for businesses in protecting their data and complying with not only local standards, but global standards as well. Over to you, Chimwemwe Bwalya. Thank you.
Thank you, Kasiku. Good evening, everyone, once again. And for those who've joined us later, my name is Chimwemwe Bwalya, and I'm a senior associate at MOIRA Legal Practitioners. And a key part of my practice here at MOIRA is advising and assisting organizations, much like yours, on how to comply with the Data Protection Act, which came into effect in 2021. But with respect to enforcement, this is an act that the enforcement commenced last year in early 2025. So I advise clients on how to comply with the act and also just practical risk management. So in this particular session, it's just going to be a very practical session, just a very high level session for you to understand what you need to do in order to comply. So I'll give you a brief overview of what data protection is, why it matters to your business, and how to assess whether or not it applies to your operations. So the starting point is, if you have a business, whether you employ staff or you operate as a sole trader, you're likely to collect and use personal data in the course of your business. So this could be personal data about your customers, it could be personal data about your suppliers and your employees. So the starting point is, I've used the word personal data. What is personal data? So personal data is any information that can be used to identify an individual. So they can be identified directly or indirectly. Some typical examples that most businesses use: a person's name. So the Data Protection Act targets individuals, not companies. So a person's name, their NRC, that's the National Registration Card number, their email address, the physical address, it could be the car registration number, their phone number, anything that can be used to identify them is personal data. So you might collect these in your business in order to deliver your services, your products to the person. For example, sharing an invoice, a service update, marketing, or even to manage HR records, because this applies to the collection of personal data from employees and also customers. So regardless of whatever personal data you hold in your business, the Data Protection Act requires that you use the personal data in a lawful manner, which is just simply in compliance with the Data Protection Act. And the reason why this act is in place is because if personal data falls into the wrong hands, people can be harmed. So this can be through identity theft, fraud, or even discrimination. So you understand more when I explain about sensitive personal data. So because the Data Protection Act regulates how to collect personal data, how to use it, it's important for you to understand exactly what the Act requires of you. So this is just a high level, I think, of what I'm going to be discussing today. So the starting point now is the scope. What is the scope of the Data Protection Act? So when you are processing personal data, there are different ways in which you process personal data. You may process personal data by collecting some personal data of an individual manually, or by automated means. So what is this? Manually, you could be writing notes, personal data in a notebook. You could have a book where a person at the security desk is collecting personal data. So when this happens, the Act does capture that. So in relation to digital processing, this could be using a machine, using your computer to collect personal data. So that's the scope of the Data Protection Act. It's not just automated means digital, but even manually, if you're collecting any personal data. However, it does exclude the collection of personal data for personal use. So for example, if you collect Navanji's phone number, that is not covered by the Act for personal use. So as you interact with people, if you collect personal data for your own uses, it's not covered. It strictly applies in the business sense. So the Act applies in the full data life cycle of a business. So it applies when the personal data, the name of the individual is collected, the way it's used, the way it's stored, the way it's shared, and the retention, the deletion. It covers everything. So here you see some of the key definitions that can help you to understand how to manage personal data in your business. I've explained what personal data is. So the processing scope is what I've said, the use of personal data, the way you collect personal data, the way you store it, if you delete it. So if so you have Navanji's name, Navanji Newe. Now, maybe you missed the B. So there are data subject rights, and Navanji is entitled to have her name be correctly recorded. So what do? When you alter to amend and correct it, that is processing. So anything that you do with personal data is covered under processing, and that's what the Act governs. Now, there's a specific category of personal data, which is called sensitive personal data, and this is because this data can be misused. This data, once it's disclosed, it can pose serious harm. For example, your biometrics are personal data. Fingerprints. So you use the fingerprint to enter bank apps. You use the fingerprint to have access to your phone for various things. What happens if there's a breach and someone has access to your fingerprints? It means they can access your email. They can access so much. So that's why sensitive personal data is protected. So even when it comes to your gender, your race, even political opinions, these are things that can be used to discriminate against a person if these things are disclosed to others. So the Act is very strict when it comes to processing personal data that is categorized as sensitive personal data. So it's important for you to understand the distinction because, for example, with respect to transferring personal data outside, the Act does allow transferring personal data, but there are strict conditions for transferring personal data outside Zambia. However, for sensitive personal data, it has to be done here in Zambia. It has to be, when it's collected, it has to be stored here in Zambia. The Act is very strict in relation to localization of personal data that is sensitive. So you need to be able to distinguish within your organization when you collect personal data and when you collect sensitive personal data. So another important distinction, a key definition is a controller and a processor. Why is that? The Act says a controller and a data processor must register under the Data Protection Act with the Data Protection Commission. And it also says that a controller and a processor are the people that are subject to the regulations under the Data Protection Act. So who is the data controller? Who is the data processor? The simple definition is that a data controller is a person who determines the what and how of personal data. So they determine what is the purpose of this personal data that we are collecting. So if we're collecting personal data from an employee, why are we collecting it? It's for us to execute an employment contract in accordance with the Employment Code Act. It's for us to be able to comply with legal obligations, the Zambia Revenue Authority, NEMA, NAPSA, all those things. Now, when it comes to, so with respect to the how, it's determining how the controller uses the personal data. For example, how are we going to collect it? How are we going to store it? How are we going to amend it? The controller decides that. Who is the processor? The processor is the person who acts at the direction of the controller. So they process personal data on behalf of the controller. Both of these must register and they must be compliant with the act. But notwithstanding that a processor is processing on behalf of the controller, at the end of the day, the controller is the one who is still accountable, but the processor is also regulated. I'll give you an example of a processor. In this same example that I've given you regarding an employee, in group companies, sometimes you find that there's a payroll function that is given to a particular subsidiary, and the subsidiary is the one that undertakes this function for the entire group. So that subsidiary will be the processor. It's processing the payroll on behalf of a subsidiary here in Zambia. So it's important to understand the distinction. So now that you know what this means, why does data protection matter? Why? So here in Zambia, for most businesses, many of you who are here are entrepreneurs, you are directors, you own businesses. So you understand that here in Zambia, the regulatory landscape, there are just a lot of laws that you need to comply with. It's something that you know. You need to comply with tax. If you're in the mobile money sector, you need to also comply with anti-money laundering. There's just a lot to comply with. NAPSA, NEMA. If you're in the health sector, you have your specific regulators. So there's that. Now, because of the Data Protection Act, you have additional obligations, and these ones apply to everyone the same way that tax applies to all businesses. The Data Protection Act, it applies to you. And why should you comply? Because of the reason why you need to comply is the risk of sanctions is very high. So the sanctions in the Data Protection Act are the highest that you could get under the Act, 2% of your annual turnover or 40 million, whichever is higher. So that will be assessed. So if the 2% is lower, you need to pay 40 million. Where is that 40 million coming from? Simply for not complying with the act. That's why it's so important for you to understand why data protection matters to you. So what's the starting point? The starting point is you need to know that for your business, it's important for you to be registered. I did mention that. It's important for you to be registered as a controller. It's important for you to be registered as a processor, just depending. So you need to make that determination from the onset. And then another reason why it's also important to understand data protection is that if there's any breach, you are required to notify the Data Protection Commission within 24 hours of you finding out that that particular breach occurred. So that's something that you need to understand. You have a very short time frame within which to notify of any breach. I'll give you an example of a breach. So for example, health records. You have these specific health records, and then someone comes, they take a picture, they come into your office, they take a picture of the health records, and the next thing, those health records are circulating and they have your business name. That's a data breach. You need to notify the commissioner, because if he finds out from social media, what happens? you are in breach. You did not notify. So the starting point is you need to notify the commissioner within 24 hours, and then from there he'll be able to make a determination of how or whether it's necessary for you to notify the data subject. Although the Data Protection Act does require you to notify the data subject within as soon as practicable. However, in practice, what happens is that the commissioner will advise whether or not you need to notify. Then lastly, the reason why it's important to comply is that the Data Protection Commission has very wide enforcement powers. The Act gives the Data Protection Commission power through the investigators. Once they have warrants, they can come to your premises, they can inspect everything to see whether or not you're compliant. They can go through your records. The Act gives them that power, and in certain circumstances, they can even arrest people. For example, where there's obstruction. So because of this, it's important for you to comply with the Data Protection Act. So what can possibly trigger an investigation for you, for these inspectors to even come? So what can trigger is what I had mentioned earlier. Media attention. Someone posted a picture and then it's all over social media. It's on Facebook, it's on TikTok, it's everywhere. So what happens in that case? The commissioner sees it because, everyone is on social media. And what happens? That triggers an investigation. A data subject complains about you. That can trigger an investigation. The data subject doesn't even need to complain about you. Someone can say, oh, I've been seeing that this company is non-compliant. Can you investigate them? And I can assure you, in my practice, this is a very common one. Whistleblowing, we see it a lot. This is what's happening. It triggers an investigation of your business. Even non-compliance related to registration, you are not registered. So the commissioner can say, I've been seeing this company doing very well on LinkedIn. Lovely. Are they registered? They'll look at the register. They are not registered. What happens? Triggers an investigation. So it's important to understand that there are various things that can trigger investigation. So it's so important for you to be compliant so that even in the event that there's an investigation, you can show compliance. That's the important part. So I think the starting point here is for you to understand the importance of data protection for your business. So now that I've mentioned this, I will now just give you an overview of what you need to do in your business in order to be compliant. So even, for example, some people might wonder, I'm a startup, do I need to comply? Even a sole trader needs to comply, even a startup, as long as you process personal data, as long as you collect someone's name for the purpose of your business, their address, their details, their phone number, that is personal data. You need to comply with the Data Protection Act. So for businesses, as a starting point, what do you need to do? So this is what we call governance. That's why this topic was called governance. So what governance framework do you need to put in place in order for you to comply with the Data Protection Act? The starting point is it starts from the top. Leadership and accountability. The organization must appoint someone who is senior to champion privacy, a qualified privacy person who will act as the data protection officer. The Act requires you to have a data protection officer. So for startups, for smaller businesses, this can be the same person, but you need a senior person in leadership to be champion in privacy. You appoint that person, you designate a person as a data protection officer. This data protection officer will even be registered with the Data Protection Commission as the data protection officer, also called a DPO. They must have some form of expertise. So for the leadership, if you have two, the leadership and the DPO, the data protection officer, the data protection officer can have the expertise. But if you have one person, they must have some form of expertise in order to just champion the privacy within the organization. Then the next step, you need to establish a benchmark. You cannot improve something in your organization if you don't know. You cannot improve what you cannot measure. So what do? You need to currently right now, you need to assess what's your data protection maturity. How are you handling personal data in your business? You need to understand that. You need to have an internal scoring methodology. What are we doing in relation to data protection? This is what the Act requires. What are we doing? Are we complying? So the baseline at the moment, the benchmark is the Data Protection Act. When you're starting, you cannot meet everything, but you need to know. Maybe in your business, there are some things you may be doing right now and you'll be able to tick. If you're not registered, obviously you don't tick that and you say, okay, we can, right now, you're just assessing, you're benchmarking. What are we doing? What aren't we doing? So these gaps that you identify, or even whatever you identify, it can help in order to regularize your business affairs. So that's just the starting point. You need to benchmark what's happening within your organization. Once you benchmark, what's the next step? The next step is to map your data, your personal data processing activities. What does that mean? You need to have an inventory of personal data that you process. You need to understand what personal data do we collect. We collect names. Yes, we collect NRCs, but we also collect the sex of a person, gender. Gender is sensitive personal data. We collect biometrics, sensitive personal data. We collect trade union data for the purpose of employment. That's sensitive personal data. So you need to understand what personal data are we collecting and what's the lawfulness. Lawfulness, what that means is that what's the purpose of us collecting this personal data? You need to map. Why are we collecting it? Because sometimes you might find that you're collecting personal data which you don't need, because the Act requires you to only collect personal data that is necessary. For example, you want to give someone employment and you're asking, also give us your village information, give us your grandmother's details. Why are you collecting that information? So it's so important to understand what you're collecting. That's the starting point. You map, you have a record of your processing activities. Once you do that now, that's when it comes to remediation. You have your benchmark, you've seen what you're doing, you have a record of your processing activities, you get those two together, and now you say, from the findings that you have, you say, we need to now start fixing these issues. So if you're not registered, you need to now say, we need to fix it by registering. If you don't have the right policies in place, you need to do that. Then you also need to understand risk management. We've seen the risks. For example, people are leaving personal data carelessly on desks. Personal data is not locked up. Anyone has access to personal data. What do we need to do? You need to manage the risks. So this is the step that you need to do for your business right now. So as I said, the goal right now is to advise on the practical steps of what you can do to comply with the Act. Then the next step is building a privacy program. What does that mean? You need policies in place. The Data Protection Act requires you to have data protection policies in place, privacy policies, a data protection policy, cookie policies. You need to have all these things in place. You need to be ready for audits. What happens if there's an audit, if there's an investigation? They're going to check, what's your privacy program? You need to now design a privacy program.